you, Deputy Polling. Good afternoon, everyone. Please be seated. The case that we have on the docket this afternoon for oral argument is the State of Texas versus Carlos Mora. And may I please have the announcements of counsel?
Patricia McLean for the state, the appellant.
Good afternoon, Ms. McLean. And how much time would you like to reserve for rebuttal?
5 minutes.
Okay.
Mark Bennett along with Tom Abbott for Mr. Mora.
Good afternoon, Mr. Bennett.
Good afternoon. Thank you for having us.
All right. Counsel, we'll be ready when you are.
Thank you, Your Honor. May it please the Court?
You may proceed.
Good afternoon. My name is Patricia McLean, and I represent Harris County in the state of Texas in this matter. We're here today because no matter how this Court chooses to examine Section 21.16b of the Texas Penal Code, the statute does not offend the First Amendment, and the trial court was incorrect to determine otherwise. I'm just jumping into a few of these points in the interest of time before this Court. Even if this Court finds that 21.16b does regulate expressive conduct, that conduct is still not protected by the First Amendment. Now, under authority under Scott v. State from the Court of Criminal Appeals and in accordance with this Court's prior holding in Horn v. State from 2015, the state may lawfully prescribe communicative conduct, which includes communication of ideas, opinions, and information that invades the substantial privacy interests of another in an essentially intolerable manner. And that's exactly what the conduct we have here is doing.
There's no intent element coupled with that invasion of privacy. Have any of the other statutes that have upheld the dissemination or disclosure of photographs ever done so in what is essentially a strict liability offense with respect to effective consent, with respect to whether there was a reasonable expectation of privacy, and finally with respect to whether there was an intent to cause harm?
Your Honor, the only case I've seen where these statutes have even been addressed by the Court is the California State in the state's briefing, Iguanes, I believe. And that one, I believe, did require a specific intent. However, specific intent is not fatal, or it's not necessary to make this statute pass constitutional muster. And in fact, our statute...
and why is that?
Yes, Your Honor, to address that. The reason that's not necessary is because what we have here, it's actually a better statute because there is no viewpoint discrimination being implicated in this statute. And what I mean by that is the specific viewpoint of the people who disclose these photographs is irrelevant to this case. It doesn't matter if they are trying to call attention, look at this beautiful person I saw or who gave me her picture, versus hate speech or trying to shame someone. It doesn't discriminate based on that. The only question here is consent and actual harm. Therefore, you don't have that discrimination that specific intent would require.
Is there a case that has upheld a statute in the face of a First Amendment challenge where the statute, it doesn't have to be in the context of photography, but just any sort of statute that is a strict liability offense?
Not that I can think of offhand, Your Honor, but I'd be happy to look and provide a supplemental briefing, Your
That would
Honor.
be great.
And you just mean without a specific intent for anything
Right.
like that?
In the way,
I'd be happy to look at that.
assuming that the First Amendment is implicated and that we are reviewing the statute under a strict scrutiny standard.
Right, Your Honor.
Okay.
There is,
Thank you.
This is not directly on point, Your Honor. It actually goes to a more of an intermediate scrutiny analysis, which I'll talk about in a little bit. But Renton, which is a Supreme Court case which has to deal with zoning for adult movie theaters, and the city of Renton, they wouldn't allow them within 1,000 feet of schools, churches, parks, things like that. And there was no specific intent or anything like that for that kind of statute. It was just essentially a zoning ordinance. And the Supreme Court eventually found that that was a content-neutral statute, even though it did essentially specify out or distinguish adult theaters versus other kinds of theaters because of the secondary effects theory, which I'll discuss in just a moment. But that's just to try to touch on your question, Your Honor. It didn't have to do with the specific intent of those. Specific intent was not required in there. But I know that's not directly on point, Your Honor.
I have a question for you on this.
Yes, ma'am.
Thompson says, when the intent to do something that if accomplished would be unlawful and outside the, when the intent is to do something that if accomplished would be unlawful and outside First Amendment protection, such as intent to threaten or intimidate, such intent might help to eliminate First Amendment concerns. But when the intent is something that if accomplished would constitute protected expression, such intent cannot remove from the ambit of First Amendment conduct that is otherwise protected expression. And we're bound by Thompson. How do you address that?
Just as I said, Your Honor, earlier, that there is specific intent does not make it necessary to pass constitutional muster. And in fact, ours is even better than that statute. I know that the intent can be important when trying to decipher criminal conduct, things like that, for example, talking with minors, or the fraudulent possession of ID statute, which this court addressed in Horn. However, this statute it's actually more neutral than those specific intent statutes.
Here's the problem. Just a second. Go ahead, Justice Court. I'm sorry.
To me, we're not looking at whether it's neutral. We're trying to determine as to intent whether it's narrowly tailored or instead overbroad. And if there's no intent requirement, isn't there a risk that it's sweeping in constitutionally protected speech?
No, Your Honor. And the reason for that, there is an intent element. It's not specific intent, but there is an intent element to the statute. This statute does not prohibit an accidental disclosure or anything like that. You have to intentionally disclose this. You also have to do it without effective consent of the depicted party.
I have a question.
Yes, sir.
Here's the only thing. This statute is fine. We have more leeway when serious privacy interests are implicated. What that Thompson teaches us that. Now, here's the problem. Overbreadth analysis is not necessarily addressed to the person who does the act. It's for it chills. First Amendment overbreadth analysis is about chilling the First Amendment rights of third parties, of other people. It's overbroad. It may sweep in innocent behavior, or this is all about creepy behavior. It sweep in non-criminal behavior into its ambient. So what happens, and this is what concerns me, what happens, it says disclose, all right? That's here, you show somebody, you disclose it. What happens, and it gets on the internet or it gets forwarded? What about the fifth, sixth, seventh, eighth person down the road that it discloses it, and then that person discloses it to number 10, 11, 12, and 13. 13 discloses it, and some third party, which under the statute identifies the person. Oh, that's Sally Joe, I know that. Therefore, that the statute has been satisfied, it seems to me, for everybody who disclosed along the whole chain of disclosures. But these are the people who had no knowledge of consent, no knowledge of the privacy expectations, no knowledge of anything. They just were doing a creepy, vulgar thing, showing, here, look at this thing. But if it is identified, if that photograph is identified somewhere down the chain, then everybody in the chain is guilty in this offense, and they had no intent to do anything, had no intent to what's the statute say, cause harm. So I'm just wondering, wouldn't intent to cause harm eliminate the First Amendment problems with this statute, if there are any? And I say, what about the behavior of the 13th or 14th disclosure down the road who has no knowledge of the acquisition of the image? You know what I'm saying? Somebody took the picture, acquired the image, disclosed it, and it gets disclosed on down the chain. Say, what about number 12 who discloses it? The 12th guy who gets it said, ha, 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 look at this, discloses it. Is he guilty of this, violating the statute?
If all of the elements are met, if there is harm from that 12th disclosure, if there is no effective consent and intentional disclosure, and that person is identified by the 12th person or someone subsequent thereafter, then yes, the statute is satisfied.
That's my problem. That is the problem with the statute, and that fits right into overbreadth analysis, because it sweeps in some, I mean, it makes otherwise non-criminal behavior, creepy behavior. I get it. We're past good taste here. Creepy behavior, but it criminalizing this behavior of this guy who's just being a vulgar person and with no intent to do any harm to anybody.
And Your Honor,
that's why Justice Bland said the strict scrutiny, it's a strict liability crime. I mean, can we do that in this context?
And, Your Honor, the reason for that, for this kind of situation, for this particular type of conduct, charging the 11th, 12th, 13th, 200th person, it is necessary to actually fulfill the purpose of this statute, which is the purpose of this, the entire purpose is to stop this harm to these depicted parties. And if the only thing you require, for example, if the only person who's liable is the first person who initially discloses it, well, that doesn't stop 200 more people from
I get
spreading.
that, and I'm very sympathetic to the statute and the purposes of the statute. It's a worthy statute, but I'm afraid there's my concern is how far out does it extend, and how many people who engage in behavior that they have no idea is criminal. I mean, how far out do we reach it? I mean, how long does it last? There's no time limitations in the statute, and that is the only concern I have, and it's only a concern for overbreadth, like Parte Low, where they did away with the telephone solicitation of sexual solicitation of minors act on telephones, and it was because it might chill the First Amendment rights of third parties, and that's I'm struggling to get around that in this statute.
Yes, sir. And it is a legitimate question, obviously, but in this context, it is necessary. And
Wait, hold on.
Yes, ma'am.
Necessary.
Yes, ma'am.
Even if it's necessary to accomplish the goal of the statute, that doesn't mean that it's constitutional under binding precedent for the First Amendment. So putting aside whether it's necessary to accomplish the purpose,
Right.
why is it okay under First Amendment law?
Yes, ma'am. The reason that this is okay is because you have, although you don't have specific intent, you have effective consent, you have harm, you have intentional disclosure, and reasonable expectation of privacy. All of those together substantially limit the scope of the statute to the 10th, the 20th, the 30th person, things like that. And all of that goes, and that the fact that 200 people might be doing the exact same thing, the exact same conduct, and fulfill the elements of this statute does not make it substantially broad, because that's only one type of action that this statute is prohibiting, not 200 different types of conduct, if that makes sense.
The same conduct can be done 200 times.
Right. Therefore, it's just one type of conduct, so it doesn't substantially reach protected methods of expression. So other photographs would be fine, non-identified photographs would be fine, non-harmful photographs would be fine, consensual photographs would be fine. All of that is fine to disclose, and even written commentary of, oh, such and such person has loose morals, or something along that nature, which would accomplish the same thing as these photographs would. None of that is prohibited by this statute.
So say there is a congressman who disseminates a picture that doesn't identify him outside of his marriage, and then that photograph is later disclosed and then widely disseminated. And arguably, the photograph is being widely disseminated by others to represent that the congressman is not fit to hold public office. Isn't that, content-based discrimination? I mean, probably the people disseminating it know that he didn't consent to the dissemination of the photograph. And so if that photograph had been disseminated widely, are the people that are disseminating it probably in the context of saying, I don't think this person should hold public office? Are these people guilty under the statute? I mean, it was a private, initially a private photograph. It was probably not disseminated with anybody's consent.
If you do fulfill the elements of the statute, Your Honor, then that would be a violation here. Yes, ma'am. And yes, the short answer is yes, Your Honor. If all of those elements are
Does
satisfied.
that chill political speech? Obviously, some people might say, well, the electorate has an interest in knowing that a congressman engaged in conduct that is not in alignment with perhaps their political values, their moral values.
Yes, Your Honor. And respectfully, with your hypothetical, that gets more into the facts of a situation, which be more appropriate for an as-applied challenge. And what's important here in this facial challenge
But
is
you
that
don't deny that this could implicate political speech. It could implicate artistic
public
expression.
speech. Yes, Your Honor, it
Yeah.
could.
So
Yes, ma'am.
we're beyond the fact that the First Amendment applies. And the question I guess I have for you is, say that we assume the First Amendment applies, that this is content-based. Just assume. I know the state doesn't concede that. But that, there is a compelling state interest here, which is the protection of the privacy of the individual depicted. How would you distinguish, if you were going to write an opinion that said this is a narrowly tailored statute that targets this state interest and nothing more? How would you distinguish Thompson, and what would you say about the subsequent dissemination beyond the people that might be familiar with the person and might know there was not consent?
Yes, Your Honor. And I see my time has just expired.
I
May
know.
briefly
Our questions
conclude?
have taken you past your time, so go ahead and answer that question, and we
Thank you,
will
Your Honor.
add some time to Mr. Bennett's time, and we will not deprive you of your rebuttal.
Thank you, Your Honor. And in short, Your Honor, this statute, assuming it is a content-based restriction on protected speech, the interest is obviously compelling, and it is narrowly tailored given all of the hurdles you have to get through to even make this offense. All of the elements themselves, all of the affirmative defenses that will apply to this case, it substantially narrows the scope of what would apply or who could be charged under this crime. And
How does it, you already accepted my hypothetical of it being passed down to 100 people. How does it protect the 100th person, who has no knowledge of anything and doesn't even know where the picture came from?
the interest here, and that goes back to the overriding interest of this entire statute.
And that's why I'm worried about overbreadth.
Yes, sir. And that just goes back to my original, if many people are doing the exact same thing, first of all, and with flushing out with facts, there would be clues as to, who did you get this from? Is this person identified? For example, if the 20th person stops identifying that person and just kind of puts it out there, arguably they have not violated the statute because they're not identified anymore. Or if there's no harm showing, things of that nature.
I understand that, but suppose Mr. 10th disclosure is walking down the street, cop walks up to him, taps him on the shoulder, says, "Hey, buddy, come with me. You violated a statute." What do you mean? You disclosed a photograph a month ago that someone identified in Albuquerque, even though you live in Houston. And he did, and all the elements are satisfied, then that man is guilty of this crime.
If there's harm, yes, sir.
We're struggling with, I'm satisfied, all the elements are satisfied. He disclosed, someone down the chain 6 weeks later identified the woman in another state, and he gets dragged off the street because he's violated an offense or violated the statute. So, I mean, we're struggling with the overbreadth aspects of this. That's all we're struggling with.
Yes, sir. And just to reiterate the overbreadth analysis, it has to be substantial overbreadth. That there could be imagined certain situations in which this would infringe on speech. That's not enough to render this an overbroad statute.
That's true.
And that's the state's contention, is that though there, of course, there could always be some conceivable hypothetical or situation where this may infringe, or the statute may infringe on protected speech. Mm-hmm. However, the question, or it's not substantially overbroad. Substantial overbreadth has not been shown.
Mm.
Go ahead.
One more quick question.
Yes, Your Honor.
How does consent play into our analysis? The fact that this statute requires consent. The consent phrase is before the intent phrase, so I don't think that you can really read any sort of intent, and there's definitely not a knowledge requirement as to consent. But does the consent piece change our analysis in any way that is helpful for you?
It's one more example of how narrow this statute is. If you have for example, any lawful commercial pornography, things like that, you have that person's consent to spread their picture, their photos, their videos around. The depicted person may upload that themselves, things like that. So the consent goes to narrowing the scope of the statute significantly. And it also goes to That's actually the main point, is that it substantially narrows the scope of this statute and who it actually applies to, which is another reason why it's just not overbroad, substantially overbroad.
One more quick question.
Yes, ma'am.
So the state may lawfully prescribe communicative conduct that invades the substantial privacy interest of another in an essentially intolerable manner. We have binding law that says that too. How does that play in? Does that go to whether the First Amendment applies, or does that give us more?
That goes to whether the First Amendment should be applied to the statute at all under our precedent and under, Scott and under Horn, because those statutes dealt with that particular kind of conduct that invades a substantial privacy interest in an essentially intolerable manner that took it out of the purview of the First Amendment altogether. So it shouldn't apply to that statute.
Would you concede that in those cases the courts relied heavily on the intent requirements of harm, intent to cause harm, and intent to cause emotional distress?
I don't agree that it would be the intent to harm is heavily relied on. It is relied on by the courts, absolutely, Your Honor. However, I wouldn't concede that that's dispositive of the entire question. I mean, that statement, it looks to the privacy interest being invaded. Is it substantial? And is it being invaded in an intolerable manner? That statement doesn't require a specific intent to invade in an intolerable manner or a specific intent to cause harm or defraud or anything like that. Okay. It goes to the interest. Is it substantial? Is it being invaded in an intolerable manner? And with this statute, the conduct we're talking about does.
All right, thank you, Ms. McClain. We have taken you 5.5 minutes past your opening time, so we will add 5.5 minutes to your time, Mr. Bennett.
Thank you, Your Honor.
Thank you very much. May it please the Court.
May proceed.
I am glad that the state opened with the quote from Cohen versus California, which is essentially intolerable invasions of privacy. I'm glad they opened with that because I can talk about that for 25 minutes, and we won't have to look for other things to talk about. Let's go back to first principles. First Amendment, first principles. Speech is protected. It is protected unless it falls into a category of unprotected speech. When I say protected, what I mean is it's protected from content-based restriction. You can have content-neutral restrictions on speech of any sort, but speech is protected from content-based restriction unless it falls into a historically recognized category.
Can I jump in?
Yes, of course.
So you're saying this is a content-based restriction because you have to look at the photograph to see whether it qualifies or not. But what about the fact that the exact same photograph may qualify or not depending on consent?
Right. So it's content-based because one of the things you have to look at is the content of the image. The fact that you have to look at other things as well doesn't mean it's not content-based. If you look at...
Say that we agree with you that...
Of course.
And I think Thompson is binding on us, and Thompson basically says photographs fall with the disclosure or dissemination of photographs fall within category of protected speech.
Well,
so let's move on to compelling state interest, narrowly drawn.
Actually, I hate to correct you, Your Honor, but Thompson says that disclosure of images is speech. It's inherently expressive conduct.
Right.
We still have to get onto the question of whether it falls into a category of unprotected speech. Categories of unprotected speech, familiar to the bar, recognize the Supreme Court has said in Alvarez and Stevens, these are the 9 categories of historically unprotected speech that are recognized by the bar. And they also say in Alvarez and Stevens, 2012 and 2010 respectively, that in order for a court to recognize a new category of historically unprotected speech, the court has to be presented with evidence that that category was historically unprotected. And we're really talking Scalia here. We're talking about historically unprotected in 1791. And that's what these categories are. They're stuff that the founders would have said, well, that's unprotected speech. That's an exception.
All of this would be unprotected speech in 1791, counsel. I don't understand why you're making this argument.
I'm sorry?
All of this would be unprotected speech in 1791. The First Amendment has evolved since then, as someone pointed out in that brief.
No, in 1791, the founders wrote the First Amendment with the idea that there is certain speech that falls outside the First Amendment.
And all of this speech we're talking about in the ambient of this statute falls outside that.
That's incorrect, Your Honor.
Okay, I'm sorry, but I disagree with you respectfully.
Okay, well, so you disagree with me that the United States Supreme Court agrees with me. If you look at
No, they don't. But go on.
Okay, so if you look at Alvarez and you look at Stevens, there are these categories of historically unprotected speech. There's nothing about privacy.
How does a category become a category unless someone does it?
Right, right. So the Supreme Court says in order for a court to recognize a category, they have to be presented with evidence that it's
All right,
historically
just a second. So you're saying the Court of Criminal Appeals doesn't say that the serious invasion of when serious privacy interests are implicated is not a protected, is not
a category of historically unprotected speech. Exactly, Your Honor. Here's
so,
why.
So Thompson's wrong?
That's not the holding in Thompson.
Well, okay.
So what that is from the Scott case. The Scott case was a harassment case. It was about the interests of the listener. That's where that language came from. It came from a case called Cohen versus California, which is the fuck the draft case. It's about a jacket that said on it, fuck the draft. Cohen versus California, the United States Supreme Court used that language. Essentially intolerable invasions of privacy. That's where that language came from. But it was expressly in the United States Supreme Court case, Cohen versus California, it was about the privacy interests of the listener. It was about whether we can force our opinions on other listeners. It was expressly not about the privacy interests of the subject. In fact, in the same term as Cohen versus California, there was a case called Citizens for Better Austin versus Keefe, or O'Keefe, in which the Supreme Court made this distinction. I think I briefed this in my brief.
Let me get to the meat of the coconut here. Your contention then is that the state does not have a compelling state interest in regulating conduct that with the express target of protecting privacy.
I'm saying that it's not a category of historically unprotected speech, so whether the state has an interest in regulating it or not, they can't do it. They can only regulate speech. They can only target speech that is in a category of historically unprotected speech. They can only regulate speech based on its content if it is in a historically recognized category of unprotected speech. And that's not me, that's Alvarez, and it's Stevens. This is U.S. Supreme Court authority from the last decade. So this is not a category of historically unprotected speech. If Cohen versus California had created a new category of historically unprotected speech, then in the 33 years since Cohen versus California, the Supreme Court would have identified that invasions of privacy are a category of historically unprotected speech. It hasn't. They are not. The state can't show that the core speech here is in a historically unprotected category. Therefore, the core speech here is protected speech, because if it's not in a historically unprotected category,
but protected speech can nonetheless, I mean, if there is a compelling state interest, you're saying it's absolutely unregulatable.
Unregulatable based on its content, yes.
Even with a narrowly tailored...
And a narrowly tailored statute is one that just restricts speech that is in the categories of historically unprotected speech. And
so your argument is that Thompson, while it struck down the constitutionality of the statute, it did so on a far narrower ground than what you advocate. You advocate that it should not have even gone beyond the fact that it was protected speech, and once it determined that it was protected speech, it was Katie bar the door, and there is no ability to regulate it.
There is no ability to regulate protected speech unless it's just incidental to regulating unprotected speech. New York versus Ferber is the example, where the statute restricts child pornography. I think it was Ferber. No, it was Ginsburg. It was Ginsburg, where the statute restricts child pornography, and the booksellers complained, well, there are legitimate books that we sell that shouldn't be criminalized that this statute covers. And the Supreme Court said, yeah, those are the cases you can deal with on an as-applied basis. That's the stuff that's outside of a category of historically unprotected speech. Here, all of the speech is outside any of those categories unless it happens to be obscene, child pornography, defamation if it's false. Those are the only three conceivable categories that apply to the speech in this statute. I want to jump out of that for just a second so I don't forget during my time. The state mentioned Renton versus Funtime Theaters. They didn't mention it in their brief. I have referred to the state prosecuting attorney's briefs in a Waco Court of Appeals case. Ellis, I think I referred to at least one of the briefs in my own brief. That argument comes from the state prosecuting attorney's brief in Ellis. And what needs to be said about that, and I have briefing on it, of course, but what needs to be said about it at this point is that rule, the Renton versus Funtime Theaters rule, only applies to bricks and mortar sexually oriented businesses. It only applies to the regulation of sexually oriented businesses by municipalities and cities. And
you're saying it's a time, place, manner restriction, or are you?
No, not exactly. It's secondary effects. is what the doctrine is called. And secondary effects doctrine has only been applied to the Supreme Court in this very narrow set of circumstances, which is bricks and mortar sexually oriented businesses. So it's not something that applies here. The state wants to argue, well, we're regulating secondary effects, so we should consider it with intermediate scrutiny. That's not the law. That only applies to bricks and mortar sexually oriented businesses.
Assuming we agree with you that strict scrutiny applies,
Yes.
the presumptions are flipped. You presume the statute's unconstitutional, and then you look to see if there's a legitimate state interest and a compelling state interest, and that it's narrowly tailored.
Right.
Why is the statute not narrowly tailored?
Because it restricts a real and substantial amount of protected speech. Substantial overbreadth is the opposite of
What
narrow
is the
tailoring.
substantial amount? I heard Ms. McLean to say that, look, there's no real risk of that because we put limits on the speech that this statute regulates. In other words, we require it to have been distributed without the depicted person's consent. We require that the depiction causes harm. And we require that the depiction was recorded or made in connection with a setting where there was a reasonable expectation that the depicted person would have a reasonable expectation of privacy. So those are the sort of the three narrowing things. And she said, so that really leaves the whole universe of other kinds of speech that fall into this category, but we're not regulating.
Except that speech, images, sexual images that are published without consent, that cause harm, and that are published in violation of an expectation of privacy are still protected speech. Exactly what they're trying to address with this statute is protected speech. And we know it's protected speech.
But assume we agree it's protected speech, but we do not agree that because it's protected speech, the government can't show a compelling state interest. So if
I would refer you, Your Honor, to U.S. versus Stevens, which is the dogfighting case. And in that case, the U.S. Supreme Court applied strict scrutiny. And what they said was the statute restricts a real and substantial amount of protected speech. It's therefore unconstitutional. There was no analysis of any governmental interest in it. Now, was that really strict scrutiny, you might ask? And indeed, Justice Alito asked, is that really strict scrutiny? Case called Brown versus Merchants Entertainment Association. There's a footnote, beautiful footnote, footnote number 1, opinion written by Justice Scalia, in which he says, yeah, we think we applied strict scrutiny in Stevens. So if you want an example, if you want a case study in strict scrutiny applied to a speech-restricting statute, United States versus Stevens is the case.
But wasn't Merchants? They said the First Amendment applies to regulations creating, distributing, or consuming speech. So distribution counts. But then they went ahead and reviewed it. They didn't say it was wholly unprotectable.
Right. Right. No, it's true. They didn't say it's wholly unprotectable, but where they wound up was this is protected speech, and this statute as well is unconstitutional.
I think you're arguing something that we're not talking about, because we chased Ms. McLean around the room about overbreadth and drawing the statute more nearly. So I think we may have leaped to strict scrutiny, and we're not certain that we have a problem with the overbreadth is the only thing we have a problem with on this statute under strict scrutiny grounds.
So if a statute were not substantially overbroad, Your Honor, if you were correct about that, and I'm not going to concede that you're correct, because Alvarez and Stevens say, no, this is not unprotected speech.
No. I thought strict scrutiny was protected speech, so we have to apply strict scrutiny.
You apply strict scrutiny if it's a content-based restriction.
Well, which this may be.
So it is. First question, does it restrict speech? Well, this is inherently expressive conduct, which is speech. Second question, does it restrict the speech based on its content? Lowe and Thompson said the test is if you have to look at the content of the communication, it's content-based. More recent U.S. Supreme Court case, Reed versus Town of Gilbert, says that a statute is content-based if it restricts speech based on its viewpoint.
Where are you? We spot you the content-based, okay?
You're spotting me content-based. Okay, so first, is it speech? Yes. Second, is it content-based? Yes. Third, is it substantially overbroad?
Okay, there we go.
Yes,
okay, bingo. Argue that.
And here's the argument. The argument is that speech is protected unless it falls into a category of historically unprotected speech.
Oh, here we go again.
Well, I mean, here we go again, because this is what the court said in Alvarez versus Stevens, and that's the court with the big C. That's the United States Supreme Court. None of these cases were even briefed by the state. I mean, this is the way that United States Supreme Court law has developed on the First Amendment. Alvarez, Stevens, speech is protected unless it falls into a category of historically unprotected speech. Yes, there might be other categories of historically unprotected.
Protected. You keep saying protected. This is protected speech. We're applying strict scrutiny to it now, so we're worried about overbreadth here.
You apply strict scrutiny because it's a content-based restriction.
Yeah.
Whether it's protected speech or not, you apply strict scrutiny because it's a content-based restriction.
Yes.
You would apply strict scrutiny, for example, to a statute forbidding child pornography. Well, the fact that it just restricts child pornography answers the question.
Wait, why would you apply strict scrutiny to that? Because it's outside of the category.
No, because it's a content-based restriction on speech.
Okay.
You apply strict scrutiny to a content-based restriction on speech. The next question, as part of strict scrutiny, is it's substantially overbroad.
Let me take you back to a question that Judge Coy asked. What is the effect of consent and the requirement that this has to be without the consent of the depicted person? Does that take it out of the area of
the proper
speech?
I'm sorry to interrupt, Your Honor. No, it doesn't take it out of the area of speech. It's still speech. Images are inherently expressive. Distributing images is speech. There is no authority for the proposition that you can't speak about somebody without their consent. And of course there isn't, because newspapers do this all the time. They talk about people without their consent. There is no authority for the proposition that you can't speak about somebody without their consent causing harm, because newspapers and political campaigns do this all the time. They talk about people without their consent causing harm. There's no authority for the proposition that you can't talk about somebody in violation of their privacy without their consent causing harm. Because again, investigative reporting does this. It invades people's privacy. People who are doing bad things do so because they're doing so in privacy, and they think that they have a privacy.
Is taking a picture of your private parts or sexual conduct, is that a matter of public interest? I mean, this is inherently private conduct.
It does not matter. It could be. It could be. It could be the case that it's a politician doing it, and it is a matter of public interest. But it doesn't matter. The public interest is not a test for whether speech is protected or not. And it can't be. You can't have courts saying, okay, only speech in the public interest is protected, because then you have the government saying, through the courts, you have the government censoring through the courts by saying, okay, you can only talk about things in the public interest. If it's outside the public interest, the state can restrict it. Well, what more power of censorship could the government possibly have? Declare things outside the public interest?
So there's no protection for the person who's got the picture taken of intimate sexual conduct with the expectation of privacy, and later on the other person decides to violate that privacy interest, violate that expectation, and publish it broadly. There's just no protection for that. Is that what you're saying?
The Constitution allows that speech unless it is child pornography or obscenity.
I have a question. So let's say hypothetically that the statute here said that you have to have knowledge that the person didn't consent. You intend to distribute the picture. You also intend to harm the person. Let's say that the statute said that. Is that different in your view, or is it your view because once it's protected speech, it doesn't matter?
Once it's protected speech, it doesn't matter.
So you're an absolutist.
I'm not an absolutist in the First Amendment. I think defamation, obscenity, child pornography, these categories of speech may very well be things that the founders contemplated being restricted. I think there's evidence that, for example, defamation was a tort before the First Amendment was written. On the issue of whether speech is inside or outside of those recognized categories of historically unprotected speech, I am an absolutist. And frankly, the Supreme Court is absolutist about it too. If the speech is restricted...
And you direct us to Alvarez for that proposition.
I direct you to Alvarez and to Stevens for that.
Let's say that we... Go ahead.
I'm sorry. Alvarez is the stolen valor case.
Right. Let's say that we do look into whether the government has a compelling interest and whether the statute is narrowly tailored. If that's the case, tell us why this statute is narrowly tailored. Is not narrowly tailored.
We don't. I reject the premise, Justice Coy. I'm sorry. I reject the premise. And if you look at United States versus Stevens, I think you'll see why. I am an absolutist on following Supreme Court case law. Let's put it that way. I'm an absolutist on following Supreme Court case law, and there's no way that the state could have read Stevens and Alvarez and Reed versus Town of Gilbert and be making the arguments that it's making here.
So the state cannot say that a person cannot, without consent, this is a different hypothetical, person cannot, without consent, take a picture of somebody while they're sleeping or something that they have no knowledge of. The state can't say it's a crime to do that, disseminate it, intending to harm them, and spread it around the world. That cannot be a crime.
That is, under current U.S. Supreme Court case law, that cannot be a crime. And maybe
Only if it's obscene.
Pardon me?
Only if
it's
it becomes obscene or child pornography.
Or it could be defamatory, I suppose. If not a photo of the person, but if I were there's in the news, there's the face swap technology for videos, and so if someone were to take a video of two people having sex and paste somebody else's face on one of the people so that the video depicts somebody who's not having sex, then that could be defamatory. It would certainly fall under the statute, but it would also be defamatory.
What language in Alvarez says this is the right framework? Can you point me to?
That says what?
That this is the right framework that we should follow.
I don't, it's cited in my brief where we talk about the list of categories of historically unprotected speech. I don't have the language off the top of my head, but historically speech has been protected if it doesn't fall into one of these categories. And that speech is unprotected unless the courts recognize it.
Speech is protected.
Speech is protected, thank you, unless the courts recognize it as unprotected.
But
and
how do we get around? I mean, you keep thinking you keep thinking. I keep reading this Thompson, and I keep saying, emotional harm. Expects activity that occurs in relatively private settings and not activity that intentionally inflicts emotional harm on the victims. I mean, there all this language about intentionally inflicting invasion of privacy, intentional infliction of distress, that substantial government interest. I mean, that has no effect on this analysis?
It's dicta.
You think Thompson got it wrong?
I think Thompson got the answer right.
Right.
I think that there's a lot of dicta in Thompson that can't be applied here. For example, the language from Cohen has been taken. I'm a criminal defense lawyer, and we deal with jailhouse lawyers, and jailhouse lawyers will take a snippet of language from a case or from a statute and try to make it mean the world.
Here's what it is. I understand. We get great writers all the time, so I know exactly what you're saying. But the deal is, you disagree with Scott. I mean, Thompson's quotes Scott, and prescribed conduct was communicated. It was found not to be protected by the First Amendment because it invades the substantial privacy interest of another in an essentially intolerable manner. And you distinguish that by saying their focus is on the victim, the person who was telephone harassed, and that you're saying we read that and apply it in a broader context, and you say that's wrong.
Yes.
All right.
Yes, that is wrong. Cohen versus California, which is where that language was from, was about the listeners' sensibilities rather than the subjects. It was dicta in Cohen versus California, even so.
I understand that, but why is that? Why do we have to distinguish between the victims and sensibilities? They're both victims in this instance. They're both victims. The person whose picture is taken and distributed is a victim, and the person who's telephone harassed is a victim. Why are we distinguishing among victims?
Between the listener and the subject is what we're talking about. Why do we distinguish? Because that's what the United States Supreme Court in Citizens for Better Austin versus Keefe said we do. It's a whole different situation when we're dealing with the subject's interests than when we're dealing with the listener's interests. You can't make somebody's telephone ring repeatedly. That's Scott. And it's not about the content of it. It's about invading the listener's privacy. Now, that language was taken by people who latched onto the language in Scott and said, oh, this is great language, and try to make it mean something more than it means. But to figure out what it means, you have to go back to where the language came from, which is Cohen versus California. And if you look at Cohen versus California and Keefe, again, the same term, you'll see that language has nothing to do with this case. If the United States Supreme Court had wanted to adopt that as a category of unprotected speech, they've had 40 years to do that, and they haven't.
So you're saying the strict scrutiny analysis only applies to categories of unprotected speech, even though in that, because it's unprotected, strict scrutiny would never really be used and applied
No.
anyways.
Let me try to put it into a couple of different frameworks, if I may have a minute or two longer. Is this actually, am I actually 3 minutes over, or was? Awesome, thank you. So, strict scrutiny applies to a content-based restriction on speech. When you do the strict scrutiny analysis, there are three situations that you could have. One is the statute restricts only speech in a historically unprotected category. That necessarily meets strict scrutiny. Those historically unprotected categories are essentially a decision by society that restricting speech in those categories, obscenity, for example, meets strict scrutiny.
Right.
The second situation is the statute is substantially overbroad and restricts a real and substantial amount of protected speech, that is, speech that's outside of the categories of historically unprotected speech. In that situation, the judgment of society is that the statute must fall. And there's other language in...
We don't look at that here.
You don't look at the governmental purpose, that just the substantial overbreadth shows that the statute is not narrowly tailored. And remember, in strict scrutiny, there has to be a governmental interest, and it must be narrowly tailored. What I'm saying is that substantial overbreadth is, by definition, the opposite of narrow tailoring. So that, and the restriction of obscenity or child pornography is, by definition, a compelling governmental interest, I suppose you could say.
So here, why is the statute substantially overbroad, or why isn't it substantially overbroad?
Because the speech that it's targeted at, which is the revealing without consent of sexual images of somebody who produced them or gave them with an expectation of privacy causing harm, there's nothing about those elements that brings the speech into any recognized category of historically unprotected speech. Now, this court could recognize a new category of unprotected speech in the right case, but the right case would be one where the state has produced evidence of a long history of that sort of speech being forbidden. There is no such evidence in this case. There are a bunch of states that have passed statutes on this in the last few years, but that's the last few years. It shows...
Have any courts other than the California court addressed the constitutionality of the statutes under the First Amendment?
As far as I know, there's a case pending in Vermont. As far as I know, the only decision is out of that lower court in California. And the way the California court system goes, it's apparently the level of a trial court but handles appeals. We don't have the equivalent here. And then in Ellis, which is in the Waco Court of Appeals, the court heard argument. They asked for amicus briefs from the Attorney General and from the state prosecuting attorney. The state prosecuting attorney provided an amicus brief and then a supplemental amicus brief in that case. There's a case called Jones, which is in the Tyler Court of Appeals. We haven't even started briefing it yet. As far as I know, that's it. The first court could very well be the first.
Do most of the other statutes require intent to harm? Do most of the other statutes have some sort of intent or knowledge requirement beyond the one at issue here, or do you not know?
I don't know the answer to that. Okay. I'm sorry. They were all written by the same people. There are a couple of activists out of Florida who have gone around the country pressing these, writing the statutes for legislators and helping legislators fit them into their state framework. So they're all fairly similar statutes, and generally they do not require the intent to harm. I think the California statute does. I don't believe the Vermont statute does.
All right. Thank you, Mr. Bennett.
Thank you. Thank you.
Ms. McClain, your rebuttal is got to get an extra minute because we gave an extra 5.5 to Mr. Bennett, and we went over a little bit. So, what would you respond to Mr. Bennett's argument that really we don't need to be looking for a narrow ground of decision? We just need to say that the U.S. Supreme Court hasn't recognized this as a category of unprotected speech, and because it hasn't, it is protected, and really any attempt to restrict it is going to be unconstitutional. What is your response to that?
My response to that, Your Honor, is that's not what the law says, and that's not what the Supreme Court says.
Okay, but you'll have to be more specific.
Yes, Your Honor,
because
absolutely.
he relies on Alvarez and Stevens.
Absolutely.
And
Yes, ma'am.
what do you rely on?
Both of those cases. Actually, all of the cases cited by the appellee, Stevens, Alvarez, and I believe he talked about Reed before this court. Now, the proposition that...
And why do you say that those cases stand for your proposition and not his proposition? What are we to read from those cases that he reads differently?
Yes, Your Honor. The actual holdings of those cases was not that if a topic of speech is not already a recognized category of unprotected speech, then the government cannot regulate it. That's not what those cases say at all. In Stevens and Alvarez, the first point that the court addressed was the government asked the court or told the court you should make a new class of unprotected speech for the animal cruelty depictions, or in Alvarez, the essentially lying about having a Medal of Valor. The court talked about it does have reticence to make new categories, but it did not foreclose on that altogether. But ultimately, the court found that there is no longstanding tradition of those recognized categories. So we're going to decline to do that here. And once they decline to make a new category, they then follow the traditional tests that we have. For example, Alvarez specifically found that the Stolen Valor Act does not satisfy strict scrutiny. It doesn't satisfy the exacting scrutiny. So it applies the strict scrutiny test after finding, no, we're not going to make a special
Because wholly unprotected speech, we don't need to worry. The government can basically do anything it wants with respect to wholly unprotected speech.
Right. To follow.
And your argument is, okay, once it's protected, whether, for whatever reason, or just assuming that it's protected, then the strict scrutiny analysis comes into play.
Right, Your Honor, absolutely.
If it's content-based.
Yes, Your Honor, and that's been the tradition since these have been about. If these, and just to go back to what Stevens, the ultimate holding in Stevens, just to wrap them all up, they actually found that the animal cruelty depiction statute was substantially overbroad. So they performed an overbreadth analysis, what they called an overbreadth analysis, and then Alvarez did a strict scrutiny analysis here. And to find, as Applee is contending, that if this is not a protected category of speech, or I'm sorry, an exempted category of protected speech, then the government can't regulate it, or necessarily any of our laws would not be narrowly tailored to fit that interest because it's not one of those categories. That essentially does away with the strict scrutiny test, the intermediate scrutiny test, and an overbreadth analysis altogether. The question for any new statute would be, okay, is it in one of these categories? And if the answer is no, should it be? If that answer is no, they are automatically going to be found unconstitutional. That's not the test. That's not what's promulgated in Stevens or Alvarez. And so that is my response to that point, Your Honor. And just to go back to your question, a little bit more on narrowly tailored, which I want to make a distinction. The strict scrutiny analysis and an overbreadth analysis are not the same thing. Those are two separate tests. Now, so there may be some intermixing of the terms, but I just want to make clear that those are two separate analyses. And while certainly the factors that would show it's narrowly tailored could also show it's not substantially overbroad, I just want to make that clear. Those are two separate tests. Now, our statute, specifically regarding your specific intent questions, and or knowledge of consent, that would narrow it further, but it's important to note that for this statute in these situations, that far of narrowing it would actually be under-inclusive of all the conduct that the legislature is trying to prevent here. So that's why it's important that there is no specific intent to harm. We have actual harm, and we have intentional disclosure. So if you have just the intent to harm, I mean, it's just going to narrow it too far, so you don't actually satisfy the objective of the statute, which is to stop all of this disclosure of reasonably private visual materials, which is one more point as to how this is more narrowly tailored. Oh, I'm sorry, Your Honor, I see my time has expired. May I briefly conclude?
You may, yes. You have an extra minute.
Now, this statute also just prohibits visual material disclosure. There's nothing said, if you want to write an opinion about a former partner or anything like that along the same lines, which would say what the photograph would show, you're free to do so. This doesn't, so it does not wholly exempt any kind of speech which is sexually derogatory or revealing of another person. That's not the
what fundamentally makes it content-based?
Actually, Your Honor, something like that would make it more of a manner restriction, because it's not just, well, I agree, like, the content is important.
You can describe the photograph in gory detail, but you can't post the photograph.
Right.
You can
And
even say, I took a photograph, and the photograph revealed, and describe it in gory detail.
That's not prohibited by the statute, Your Honor. And that's just another example as to how narrowly tailored this statute is. We're not going to stop you from expressing an opinion about a former paramour or anything like that. What they're trying to stop is this disclosure of photographs of intimate parts, things like that, that are reasonably expected to remain private, which actually infringes on the depicted party's right, First Amendment right,
I
to
might
keep
have a
those
private interest in the description of private sexual activity or private body parts.
Right. However, that's just not going to be covered under the statute, and it's just another example of how this is so narrowly tailored to the harm that's caused by these photographs, these visual images themselves. Because a person's opinion, you're always subject to somebody's opinion about you, provided it's truthful, not defamation, things like that. However, these kind of images, and that's the concern here, they follow these people forever. They have to change their name, they have to move, they have to delete their profiles, things like that. Those have real lasting harm, which an opinion might as well, but it's just one more example. I'm sorry, Your Honor.
You're saying this is narrowly tailored to the harm at issue, and to the extent that we find that there is a compelling government interest in stopping the entire harm at issue, this is the narrowest way to solve that problem.
Right. To narrow it further would essentially make it under-inclusive, so you're not going to catch what you need to meet the goal of this statute, which is to stop this kind of conduct and this kind of harm.
All right. Well, thank you, counsel, for your presentations this afternoon. Very interesting case. We appreciate very much your hard work, and we will take post-submission briefs. It does sound like there are a number of cases that are looking at these issues across the world and across the country. So if something comes to your attention, please send a letter and let us know. Otherwise, you don't need to seek permission, but just send us a letter if there's an updated case you want to make us aware of.
And she said she was going to set it free from the intent.
Yeah. I think I had talked with Ms. McLean about strict liability offenses and whether those have any special consideration in connection with the First Amendment. And obviously, Mr. Bennett, you can respond after she files her brief. Within a reasonable time frame. I don't know what your schedules are like right now, so I'll just expect that when you get to it, you'll get to it reasonably promptly and you'll respond reasonably promptly. Thank you so much.
All right.